Good evening to the students of the SLW616. Karibu sana to my class. Welcome to my class. And this is deemed to be the last class, if I may not be mistaken, and if I complete it to your syllabus is... yes, read what I posted on the screen, anyone? I said read, anyone, what I posted on the screen.
Okay, Prof. Let me read it. Welcome to the student of SLW616 for the visual class on 18th February 2023 from 9 p.m. to 10 p.m. The economics of the legal process.
Yes, that is the point, and this is the syllabus, and is the 2.6. The economics of the legal process is the last unit of you. So now, without wasting the time, let me go to our class. Yes, the economics of the legal process is concerned, and this chapter examines the economic legal procedures, including both the civil and criminal procedure. The focus is on how procedural rule affect the cost of dispute resolution, and how legal procedure generally contribute to the efficient functioning of the law. The key points, all the bullet points are here. So now I will go through and explain one after another. Yes, read the which I highlighted here. Anyone can unmute and read.
Okay, Prof. Economics are concerned with the process of dispute resolution because litigation is costly, and economic theory may suggest ways to lower this cost.
Yes, economics are concerned with the process of the dispute resolution because litigation is costly, and because you have to pay to your counsel the money, and economic theory may suggest a way to lower this cost, and how to lower this cost, and how to make the procedures, and these are the things we should have to take into consideration for the economic efficiency is concerned. The second bullet is the litigation process determines how the common law evolves because only those disputes that comes before the court can affect the legal change. If the dispute is not solved by any existing law is concerned, or the laws which are there in the international instruments where the parties are the members for that events that also not solve the problem, then the common law evolves over there and come to the rescue. Number 3 bullet is plaintiff and defendant have a common interest in resolving their disputes out of court so as to avoid the cost of trial. If you go to the court adjudication, it may involve the money, it may involve the time factor also, and hence people try to resolve amicably their disputes out of court in the form of any one of the mode of dispute resolution mechanism, we study the diplomatic way of the dispute resolution mechanisms, and that is the best way to resolve the dispute because the best judgment is settlement. Though consisting with these predictions, the vast majority disputes settle out of court. Yes, the key question then become why do any case go to trial? So if you think that if you don't want to use your money and spend your money, spend your cost, spend your time, and try to take the tensions on your brain, better you resolve it out of court settlement because that is the efficient way of settling the disputes. Then the next point is the differing perceptions or optimism model of dispute resolution says that trial occur when plaintiffs and defendant are mutually optimistic about the outcome of the trial. This model predicts the trial becomes more likely to the cost of the trial decreases and the stakes of the trial increases. See, when you context in the court, naturally we thought that the trial will be come to an end, but one after another hitch are there, and the trial will be prolonged. When the trial will be prolonged, the dispute cannot be resolved, and both the sides will have to incur the money as well as the time. And hence, they try to resolve it amicably by the out-of-court settlement in the form of the diplomatic way. The next question also say the asymmetrical information model of trial says that the trial can result when one party to the dispute holds a private information about his or her prospects at trial. The model yields the same basic prediction regarding when the trial is more likely to occur. Though each one wants to see that their contention would be proved over there so that they could win the case, and other party also makes the another ground to see that the other party may lose it by raising some other issues are concerned or bringing some of the facts are concerned in the middle. The next, the two other factors affecting the settlement trial decisions are the risk preference of the litigants and the possibility of the asymmetric stakes at trial. For example, if one party is a repeat player, and if one party say that they want to contest it and the other party want to make the amicable solution, at that instance the trial will be prolonged. When the trial will be prolonged, naturally the money also involved more, because whenever the lawyer would comes and attend to the court and he will charge, at that time the economic cost will be increased and the trial will be prolonged, and hence the headstrong party should not be there. They should come to a conclusion to see that dispute will be amicably settled out of court settlement, or through the settlements process, or by the diplomatic way of the dispute resolutions may be obtained. The next point is placing the burden of the proof on a plaintiff discourages the plaintiff from filing the meritless claims. So always the contestant which he wants to contest it, he has to prove that. So if he wants to prove it, it takes its long time, and failing which the filing meritless claims, even they try to defend by making the false allegation, false charges, and meritless claims they will make it out, so that they want to win it. They want to win it by any other means, by the hook and crook. So that's why the many meritless claims would come across over there when you're contesting in the court. And hence, the plaintiff should have to, and the defendant should have to make an amicable solution to see that the dispute will be resolved out of court settlements, means out of the court, by negotiation, by arbitration, by the mediation, by the good office, by any other means that to try to solve it. The next bullet says the process of the pre-trial discovery can promote settlement by reducing the disagreement or the asymmetrical information prior to the trial. However, it can also lead to the abuse of the allowing one side to impose the high cost in the other. In contesting, people try to adapt the unusual methods, meritless claims, and they try to make the trial become a risky, and it's prolonged, and money will be involved there. So try to adapt such a method where the money would be saved and the time would be saved and the burden would not be there on the parties. That is a headache and tension and torture, and these things would not be there if they could resolve the dispute in amicable way by the out-of-court settlements. Next, the loser pays. The rule requires that the loser at a trial to pay the winner's litigation cost. And switching to this rule has an ambiguous effect on the settlement, where it reduces the likelihood of the settlement by raising the stakes at a trial. It increases the likelihood of the settlement by increasing the riskiness of trial, because every party wants to see that they should have to win the case, and for the winning the case they make the meaningless claims also, unnecessary claims also, and they try to harass it. And when such a thing would be there, the litigation cost would be increased when the dispute will not be resolved within a stipulated time. So whenever the advocate which argue on behalf of you comes to the court and you have to pay the charges to him. And that's why the money factor will be the more. And instead of that one, they'll say that out of court settlement is the best settlement to resolve the disputes. That is the suggestions. Then that is why they say English rule discourages the filing of the low quality suits, because when you file the low quality suit naturally, and you have to adapt the different methods which are meaningless methods or meaningless claims also, and he encourages the filing of the high quality suits, because the suit quality will be increased by meaningless claims would be there, and it takes a longer time, and hence try to avoid it that such situations. Next rule says 68, rule 68 shifts the defendant trial cost to the plaintiff if the plaintiff rejects the settlement offer, then receives a lower judgment at the trial. The 3D predicts that the rule should promote the settlement by expanding the settlement range. So, in any case, at any stage of the trial, a party can try to resolve it, and they try to take back their stand also. That means they can go for the compromise. They can ask the other party to go for the compromise also, to see that the dispute will be resolved amicable way. So that is the another way. At any stage, a party can approach to the court for the compromise. Next bullet says the most common form of the compensation for the plaintiff's lawyer is in tort suits is a contingent fee. The fee is more chargeable over there, because whenever the lawyer will appear on behalf of you, definitely will charge his everything, per diem, and the cost, and the money, and the subsistence, and the staying, and the defending, and the court process. All these things that will be borne by the plaintiff that who hires the lawyer. So under the which the plaintiff pays the lawyer of a fixed percentage of his her recovery. Sometimes no, they will say that okay, we will give the 30%, whatever the outcome comes, 50%. In that way, they will make it out, and they are the many much losers, and that will be charged on the opposite side, even the cost also sometimes, because when the court decides to give the judgment, sometimes the court also award the cost, and that will be borne by the other party. Then contingent fees provided lawyers an incentive to work hard for the client by giving them a stake in the outcome of the case. However, they may distort the settlement trial decisions by encouraging too many settlements, and many promote the frivolous suits. Sometimes what will happen, the lawyers, for getting their own fees, they want to see that the compromise should not be made. They want to contest it to see that a big amount will come out. But sometimes they will lose also the big amount. The reason is the claims which they are making are frivolous and meaningless, and there is a chance of the losing them. So better it will be best to the parties to make the settlement. That is, they can save the economic burden, as well as they can relieve the tension also, and the time also they can cut short the time by settlement. That's what I want to say. So frivolous suits means meaningless suits without having any base, or the suits lacking the legal merit, may succeed in eliciting the settlement if the defendant are uncertain about the probability of the plaintiff victory and trial, as in the asymmetrical information model, and if the fraction of the frivolous claim is small. See, when the claims are many and the frivolous claims are many, and a lawyer wants to contest it by hook and crook, by following the different means also, that means the cost will be effective, and at last the frivolous state, the merits will be struck down by the court. At that instance, even the person who is engaging the lawyer, and he has to pay the burden, because he is making the harassment to the another defendant by making such a frivolous and a meaningless charges against him. So another court's delay is an important problem in the dispute resolution process, because the court will take it whenever a thing would be there. Naturally, a notice will be given to the other party. When a notice will be given to the other party, at least some reasonable time also to be given. That means it is nothing but the prolonging the trial. So defendants may be able to use delay strategically to lower their cost by sorting the plaintiff according to their time and discount rates. At that instance, both the party will see that how can they can minimize the cost, how can they minimize the time, so they can, if they could think over that, not only the parties could think, even their advocates, those who are arguing on behalf of them, they also think that let the dispute will be resolved now amicably by the out of court settlement, even though some of the time is wasted and some of the money is spent also, but the other money which is going to spend will be saved, and the other time which will be going to keep the this trial will continue, that also be saved over there. Not only the parties, even the advocates also should have to give the reasonable suggestions to the party to see that the dispute will be compromised. So in this way, there are the process and rules are there. It will be paid by both the parties, including the lawyer. The standard of the proof in a legal proceeding is optimally chosen to minimize the expected cost of the legal errors. Specifically, optimal standard of the proof balances the cost of the false convictions type of errors. Sometimes it will happen no, when they prove it a false one, then naturally it will be a burden on the other party. But generally, the court will definitely see that whenever a person will be convicted or will be liable, would be there, they want to see preponderance of the evidence, not based on the evidence. If the evidence is not properly produced over there, the court will ask for the more evidences would be there. When the court will ask for the more evidences, at the time the possibility of the frivolous charges also comes, and grounds also comes, that leads to the prolong of the trial, and the cost involved would be there, and tension involved would be there, and dispute will not be resolved. Hence, even the parties as well as the advocate should have to come to a compromise to see that the issue will be solved by the compromise means or out of court settlement. The social value of the lawsuit is the ability to induce the potential injuries to take cost of the effective care, while the private value is the gain of the plaintiff aspect of the trial minus and the filing cost. Generally, these two values will not coincide. As a result, there may be too many or too few suits from the social perspective. If the court wants to see it, cannot entertain also some of the things, but they give the chance to the person to prove it by giving the time to him, to the party and to the advocate, as well as a notice also to be given whenever a other party wants to bring to the written statement or the defense for that regard. And it is nothing but a time consuming factor, and the trial cost also increases, and the frivolous claims also comes over there, and hence the party should have to resolve it by compromise or out of court settlement. That is only the best efficiency or best method to resolve, and where the both party can save their time, the both party can save their money, the both party can be free from the tension. An important conjecture or in the economic analysis of the law is that common in evolves toward the efficiency. See, economic efficiency comes at that instance only when they could think and use the claims which are reasonable and are to be compromised from both the parties should have to agree. Even the both counsel should have to convince their own parties to see that a toss, if you are win also, it takes its own time. There is no meaning of winning the case, even the time lapse of the 30 years, 20 years, 40 years. There is no meaning at all. The fruits will not be eaten by them, it will be eaten by their grandchildren. The question for which the disputes to go to the trial is important and evaluating this claim, because only those disputes that make it to a trial can affect the direction of the legal change. But only the few things where the claim is right, that only they give the right way of the change should be there. Otherwise, the party which making such a charge should have to bear the cost of the litigant, that is the advocates paying fee also if the frivolous claims are made by the parties. So two conditions are sufficient for the law to evolve towards the efficiency. Number one, inefficient laws are more likely to be litigated than efficient laws. Even the inefficient laws are there, outdated laws are there, that also time consuming, because better you say that a latest law should be applied over there when they're resolving the dispute. And second, judges are not biased against the efficiency. In general, judges also not biased based on bias against the efficiency. If the efficiency will be made over there, they should see that yes, it is the best method to go to. Even the judges will make a suggestion to the parties to go in this way so that the dispute can be resolved amicably. The next bullet point, they say judges often decide the cases by following the president. How the judges will make it out? They following the presidents. What are the cases would be there of similar nature has come to the court, and what would be the outcome? What would be the adjudication? What would be the disposition? The same disposition would be come out better. Follow this method. That is the reason they will say the presidents, they will make it out. That is by invoking the ruling from the past and similar case. The similar case would be there, which is already decided by the competent court. The judges will make it and follow the judgment better to avoid the prolonging the things. Of course, res judicata also says, because you need not to take the time of the court, you need not to spend the time of the court, while the facts of the case is the same thing which already decided by the court earlier. The same decisions will hold good. That is called the precedents. So this is an efficient way to make the decisions under the uncertainty of the decisions cost. It can reduce the cost, it will reduce the time, and the likelihood of the judicial error are high, and there will not be the judicial error or high would be there, and because the presidents are there. However, it may be the impede the evolution of the law by entrenching the inefficient rules. Sometimes no, it's more better to create the new law over there, better to resolve the issue by following the old rules instead of keeping the new rules in the in the trial, because it takes its own time. Now, next point is that judges may affect the direction of the legal changes by seeking to impair their own biases into the law. So judges also should have to make it a suggestion to the parties that you don't bring the frivolous claims and don't bring such an inefficient laws over to the court. It is nothing but the consuming the court time and consuming the time of the parties, including the financial burden also. So precedents and selective litigations, we will follow it, how the court is decided in the earlier cases of the similar nature facts. The fact that the inefficient laws are disproportionately go trials and mitigate the potentiality of the detrimental effects of the judicial bias on efficiency. If frivolous claims are made over there, it is nothing but time consuming. Better you follow the law where the facts are the same. The competent court has decided a particular case law, which is the persuasive value, even though it is not decided in the particular country, but any other country also, it is also a persuasive value, because the foreign judgment also can be used over there as a model to resolve the disputes, because it is the reference would be there, recognition and enforcement of the foreign judgments. So plea bargaining also there. In the middle also we can bargain with the parties. Yes, the party can bargain it. The admission of the guilt of the criminal defendant to return for the reduced sentences. Yes, they can make the plea bargaining also in the middle of the trial, and the vast majority of the criminal convictions are obtained. Economic model of the plea bargaining are similar to the settlement model of the civil litigation. So plea bargaining also be there in the criminal cases in like the civil cases. The civil litigation also comes to the settlement, and the plea bargaining also comes in the matter of the criminal matters. So process of the plea bargaining represent a institutional impediments to the law probability, high penalty punishment scheme prescribed by the economic model of the crime. Suppose the high penalty crimes would be there. At that instance, the court as well as the advocates, those who are arguing on behalf of the parties, they try to see that a plea bargaining can be made, or in the civil cases are concerned, better you go for the settlement, that is called out of court settlements. So in contrast to the United States or the European countries or any other countries historically discourage the use of the plea bargaining. Actually, the plea bargaining we should not eliminate it. Yes, at any stage of the case, the plea bargaining would be introduced over there, that will be highly encouraged. And the European trials, however, tend to be less costly from the American trials and offers the defendant the fewer procedural protections. So American trials are very much costly because the cost is very much more. They charge according to the arguments for hourly basis, and the defendant and the Britishers, means Europeans, they charge you very less, and better you take such a suggestions from the advocates, suggestion from the court, to see that how, instead of prolonging the dispute, better they resolve it, if it is a criminal case, through the plea bargaining; if it is a civil case, through the settlements. I don't know whether the students are following or not, because I am trying to make it. The overall gist of these points is nothing but settlement is the best solution. Is it clear?
Then, yeah, Prof. Then a settlement out of court.
Yes.
Oh, settlement out of court. Always it's better than.
Always it is the best method. Settlement is the best judgment. In the criminal cases, plea bargaining is the good way. In the civil cases, out of court settlements. So the bail system is designed to balance the benefit of the allowing the criminal defendant to remain the free prior to the trial, given the presumption of the innocence, against the risk that they will flee and possibly commit further crimes. The optimal bail is therefore the increasing the likelihood that the defendant will flee. Suppose in the criminal cases are concerned, if the bail is not given over there, he will be behind the bar. Suppose the bail is given to a perpetrator at the time, and he wants to tamper the witness also, and he wants to flee away from the country. So many business tycoons, they try to take the loans, millions of the loans, and they will run away from the country and take the asylum in the other country, because they make the investment in the other country. That's why the country also protect them. So bail, when should be given, when not should be given, the court should have to be very careful before giving the bail. The reason is he may flee, he may run away, or sometimes no, they impound the passport. They will take the passport so that he could not flee from the country. Flee means run away from the country. Is it clear? Yes? Did you got my point? Bail, when should be given, when should not be given? The court should have to think twice before giving the bail. If the bail is given, at the time, the person will tamper the witnesses, evidences, or he may run away from the country. Did you get my point? Regarding this point is concerned, the bail.
Yes,
It is a balance between allowing the criminal defendant to retain free prior to trial. Till the trial would be there, he should be free. The presumption is he should be treated as innocence till it will be proved. So now next point is enactment of the sentencing guidelines in the 1970s and 80s curtailed the discretion of the judges into the imposing the criminal sentences. One goal of the reform was to eliminate unwarranted disparities in sentences for offenders convicted of the same crime. Another was to stiffen the sentence in order to enhance the deterrence. Suppose the sentence method of it, whether it be flexible, whether it should be stringent, depending upon the hardcore criminal, it will be decided. Sometimes they will be flexible, they will be released because of the good behavior in the jail. And sometimes, if they be released, again they do the same type of the offenses twice. And they become a hardcore criminals. So better not to allow them to come out of the jail, prison. So, if they stiffen the sentences in order to enhance the deterrence, they stiffen the sentences in a such a way there should be a deterrent effect would be there. When the deterrent effect would be there, naturally nobody would come forward and to do such a thing, or he will not be released at all. The empirical evidence is mixed regarding with the guidelines eliminated disparities in sentencing. The sentence method depends upon the country's approach. For instance, Tanzania says capital punishment is must. India also says capital punishment is must. Hand to death should be there. Yes, it should be there. Of course, rarest of the rare cases can be done, but it should be there. So, as for the deterrence, there is some evidence that state imposed the guidelines have actually caused the crime rate to increase. The guidelines should be followed, and in your earlier classes also there, thousands of the empirical studies made. What is the cause of the crime? And we studied it in our earlier classes. Then the Fifth Amendment protects the criminal defendant, of course, the countries, against the self-incrimination. Yes, self-incrimination should not be there, and an economic analysis suggests that the right to remain the silent actually helps to make an innocent defendant and the protestations of his innocence more believable. In general, no, if you are very much silent would be there, then naturally the cases will not be counted a lot. If you accept it, then the punishment will also be decreased instead of prolonging it. If you prolonging it, then the punishment the punishment idea is behind them because he is intentionally prolonging the criminal trial. When the criminal trial is prolonged in such a way, naturally it is the more intention that he would like to come out of it. And at that instance, he will become a hardcore criminal and he may kill also if he come out of the jail. In the civil litigations, morally, it is a very less possibility would be there, but the civil litigation, he will be run away from the country because if he has taken the debt so much by the government or by the banks or through the people, then he will become insolvent. At that instance, he will flee from the country because he keeps a lot of amount in the other countries as an investment. And I don't know whether you have the knowledge or not. Swiss bank. Do you know the Swiss bank? Yes?
Sorry, Prof. Can you repeat the question?
Yes? Swiss bank. Do you know the Swiss bank?
Swiss bank.
Yes.
Probably I don't remember it exactly, but I
All
think
the
I've heard
business
about it.
tycoons, politicians, they will keep the amount in the Swiss bank. Swiss bank never reveal it how much amount would be there.
Is it a special bank for the for maybe person within the state they can keep their money out of the bank which is outside within the country?
In the country, if it is there, the High Court or the Court of Appeal will ask them to show the details.
Yes.
And that's why
But if
many people in the world, I am speaking, those who are getting the money, black money, they never keep in their own banks. Neither in the name of their relatives also. They try to keep the money in the Swiss bank. And the Swiss bank, they say take the money, they never reveal it, how many dollars, how many $1,000,000 they kept it over there. Because Swiss bank, they will keep the money and they will make it for the transactions by giving the loan to the other countries also. And they will get the benefit out of it. Even they can give to that country and where that countryman has put it. And they will make the money. With the money, they will make the money. And they never reveal it. Nor any court is having any power to Swiss bank to reveal the account holders' details. No. It will not listen. So that's the reason the people will keep it in the Swiss bank. Because the amount will not be declared by anyone. So again, here the people's against the unreasonable searches and seizures. The law enforces the right of the dissolving the use of the evidence obtained by the illegal research, the exclusionary rule. Some scholars, however, have proposed the torch liability for the unreasonable searches as an alternative remedy. See, searching also they can make it out in other country, provided other country will allow them to search. How much this fellow has made the investment in other country, in other business, provided if they are binding each other of the country by the bilaterally or multilaterally, at that instance it can be done so, otherwise it cannot be done. Because every country is a sovereign country and hence no country will enforce. Okay, if they want, they can file a case in the International Court of Justice or the regional court, depending upon the nature of the offense. Depending upon the nature of the offense, they can make it so, otherwise, they cannot make it so. So, that is another factor. So, procedures and rules, both the litigations in the international dispute settlement is concerned, or the law is concerned, or the law and the economics is concerned, they will try to make it out in a such a way where the less expenses would be made to the parties, plus the justice to be done, and it seems to be done. What is the use of justice if it is given after the 40 years or 30 years or 50 years? By the time the person who filed a case is no more, their legal representatives may enjoy it, number one. Number two, at the cost of getting the justice at the faraway time, it is not a true one to be there, because both are suffered in the same way. A person who won it, he will weep in the home, but a person who lost it, and he will cry or weep in the court. That's only the difference. Once I already told you that. After a prolonging time of the justice, if it is won it also, but it doesn't have its value, because he spends a lot of amount for the consultancies, for the advocates, for the charges, for his coming and going, and at last he got also justice. It is not that much worth enough to get the justice, because he also suffered. By all means, whatever he got is merely a sum, a solace amount to him, not more than that. So both the parties will lose it, and hence they say out of court settlement is the best settlement, and the most of the settlements they will do it by the amicably, by following the diplomatic methods. By the diplomatic methods, you can save the money, you can save the time, and you can resolve it without encroaching on the sovereignty of the each state, because the states are members of a particular declaration, the states are the member of the protocols, the states are the member for the even treaties and conventions, either bilateral or multilateral or special agencies. These are all done by the UN. Again, UN will take care of it. And the special bodies, the UN make it to become a special agencies also. So, in the WTO is there, and it is nothing but the special agency of the UN, World Trade Organization, the TRIPS agreements. These are all is the part of the WTO makes the TRIPS agreement for the all the business transactions are concerned in the world because of the liberalization and globalization. And that's the reason we can say any country can invest in other country, because investment of the foreign investment is very good for the growth of the country and to increase the GDP also. If the rich country is having a lot of technical advancement would be there, yes, they can bring the advanced technical things to the country, and they will try to extract the minerals, extract the things, and it provides the employment to the local people, plus the GDP of the nation also increases when there is exports. And the government also levies certain a license to them to do, and whatever the product they are selling it on that, they will get the percentage also. When you get the some percentage, it is nothing but less investment and more profit would be there. For instance, you take the gold mines, the gold things. The Tanzania cannot purchase such a technology to make the gold, purified gold, to make the 22 carats and 24 carats and 18 carats. The raw gold will be sent to the South Africa because they are having the latest technology. Because the world technology there in the South Africa for the gold mining is concerned. And earlier, it is only the South Africa which is having the monopoly in the gold trade. And earlier, we can travel to any country but not South Africa. It will be written. But now there is no such a thing would be there. One can travel to any country because there is a linkage between the one country to another country. If a country doesn't have a good relation with the neighbor country, if the country doesn't have a good relation with the advanced countries, the country will not grow. Because when you take and when you take and when you give, then only the relationship would be more and the bond would be more. Otherwise, it become a waste. Whatever the products would be there in the country, if it is more there in addition to the consumption, better you export that product to the other country and you will get the foreign exchange also. And you can import the other products or the things from the other country because you can less amount and more advancement you can do it instead of when you want to buy a glass of water, can you start digging the well? I repeat the question. When you want to quench your thirst, when you want to drink a glass of water, could you start digging the well?
Digging the what, Prof?
Well, for the water, WELL.
Yes, Prof. I know it. Then the question is.
When you want to drink a glass of water, means when you want to quench your thirst, can you start digging the well?
Probably no, Prof.
You don't know what is well because if I tell in the Kiswahili, there is a wrong meaning called kisima or kisimi.
Prof, that is
That's why
Kisima,
I did
not
not utter the
Kisimi.
word. You don't know well.
I know it, Prof. Kisima. I understand it. We use them always.
You draw
Even where
the
I'm staying,
water from the well, is it not?
that's what we do.
You don't know the well. I say well images. You draw the water from the well.
Well,
See, this is the well.
yes.
That's why I did not use the Kiswahili word. I don't know which one is the right word.
it, it is Kisima.
Yes, Kisima, when you
Kisima,
are feeling
yes.
thirsty for the glass of water, could you start digging the well?
No.
There is no economic efficiency would be there. You better buy the water
Sure.
or you export the water.
Mhm.
But it is useful at the time. Public at large would be utilized over there when there is no water. The government will come to the rescue. They dig the big well and supply the water to the all the village people. Or they can make the bore. You see here the boy is there using the bore. Hand bore. So economic efficiency would be there in resolving any issues are concerned. Resolving the any issues are concerned, economic efficiency would be there. So these are all the points which we say about how to reduce the cost in the dispute, reduce the time in the dispute, what the mechanism should be used by the parties. If one mechanism fails, the other mechanism should have to come to the rescue. In the beginning, both parties are adamant. As the time goes on, the parties becomes soft. Am I right?
Yes.
Asante sana, sikiliza darasa. Mungu akubariki na kukulinda.